All right, thank you. Let me just get my screen shared. Just 1 second. All right, you can all see my slides, right? Let me test. Okay, working. Okay, so welcome. What should I do with all of my stuff? Um, like, um, my name's Corey. I'm an attorney at Lakeshore Legal Aid. I'm sure that you've all heard about Lakeshore from Tracy, but Lakeshore Legal Aid is a nonprofit law firm that operates in Oakland, Wayne, and Macomb counties. And we help low-income folks with civil legal issues, and we also help seniors with civil legal issues. And I'm very happy to be here, and I'm going to go ahead and get started. But yeah, feel free to ask questions as we go. And I am a very fast talker naturally, but I'm going to do my best to slow down. I'm always telling myself, don't need to be in a rush. Um, so your stuff, spoiler alert, you can't take it with you. These conversations are a little heavy because they are dealing with death and mortality, which certainly isn't my favorite topic to talk about. But that's just, a reality of it. And these are important conversations to have, even if they can be difficult conversations to have. Um, but an estate is all of the things that you own. And then an estate plan is going to be what happens to the things that you own when you die. At Lakeshore, we believe that everyone could benefit from an estate plan, regardless of how much or how little you own. So today we are going to discuss designation of beneficiaries. We're going to talk about transfer upon death deeds, which are otherwise known as Ladybird Deeds. We are going to talk about joint ownership. We are going to talk about trusts, and then we'll also talk about wills. So, some general requirements for making an estate plan. First, it must be in writing on paper, it must be signed and dated, and it must be properly executed. I know I said signed, so there must be a valid signature on it. The person creating the will is called a testator, and they must be 18 years of old, 18 years of age with sufficient legal capacity. And the will becomes effective upon the testator's death. We also need two disinterested witnesses. The witness's role is really to gauge the capacity of the testator to make sure that the testator has the legal capacity. And then also, we do at Lakeshore recommend notarization of a will. It is not required in Michigan, but we do recommend because a notary will verify that your identification is correct. So it protects against like forgery. So it just adds kind of a layer of protection to the will if you have it notarized. I do want to talk a little bit more in detail about the capacity for decision making. What does that mean? And a person's capacity can change due to internal and external factors. But ultimately, in order to make legally binding decisions, you must be able to understand, make, and communicate your decisions. You must be orientated as to time and place. Now, keep in mind that capacity and disability are not the same thing. Somebody could be disabled, but still have legal capacity to make a decision about themselves. So it is the same, it is different. And capacity can change depending on the day. So it can be impacted by things like, your blood sugar, whether you took any medication that day, how you slept the night before. When we do estate planning at Lakeshore, we always do a capacity questionnaire at the beginning of the visit. And if somebody doesn't have capacity that day, we may, reschedule that meeting for a couple weeks later. And maybe they would have capacity on a different day, but ultimately we would need to see that the person is able to, understand, make, and communicate decisions to us before we would go ahead and execute that estate planning. So I think one of the most um, popular conversations about estate planning really revolves around whether to probate or not probate. And I think probate is kind of like a dirty word, right? It's like the big scary thing. Um, but what is probate? Probate is a division of the court system. If you do have to probate an estate of someone who's died, there is a filing fee to open the case, and then there is also an inventory fee, which is based on the value of the estate. So the value of the things that were owned by the person who died. Fees vary based on the county. So you could look up your local county's probate court website to see what the fees are. Another thing to know about a probate estate is that there must be a notice sent out to the deceased creditors. So, one potential disadvantage of probating an estate is that if the person who died has any unsecured debt, like credit card debt, the creditor would need to be notified of their death and they could make a claim against the estate and then they would get paid first before any family members. So there are exemptions to probate or ways to avoid it. And that includes putting property into a trust. It includes joint ownership with rights of survivorship, and then also transfer upon death or beneficiary designations. If you pre-plan accordingly, there are times when you can avoid probate altogether. But it's very unlikely that we could ever say with 100% certainty that somebody could avoid probate unless you have a trust. Because even if you pre-planned to the best of your ability and you did everything you could, somebody may still want to contest the will. One of the descendants or somebody, um, a family member could always contest the will. So there's not really a way for us to promise that you'll never be in probate court, but there are ways to plan so that it's unlikely that you would need your family would need to probate your estate. But really, when deciding, I'd say the biggest disadvantages of probate are, that inventory fee that would have to be paid, the notice to creditors if there is unsecured debt in the estate, and then, ultimately, if you're in probate court, you do have a judge making the decision about who inherits what. And, that can be hard. You would essentially have a stranger making family decisions. So that's one disadvantage of probate court. In some situations that can be good. Having a third party oversee a large estate might be, to everyone's benefit. But if we're talking about a relatively small estate in family disputes, not everybody wants a stranger making those decisions for them. All right, so we're going to go through a few different types of things that you may own and talk about kind of how those things um, could be transferred upon death. So life insurance is a contract that is between you and the insurance company, and it involves premiums that must be paid in full and on time. A life insurance policy will have a beneficiary set on it, and the beneficiary will have no access to any funds until the owner's death certificate is produced. Um, a life insurance policy is always going to transfer outside of probate. It is not anything that gets addressed, it doesn't need to be addressed in the will, and it would never be probated because it transfers upon death to the beneficiary that's been assigned. You can have multiple beneficiaries on a life insurance plan, and beneficiaries do not have to be heirs or relatives, so it could be a friend. Um, One thing I will say when I'm estate planning for people, I will sometimes refer to the life insurance in the will just to alert family members that it is there. And so they remember that they need to provide the death certificate to the insurance company. But again, it is not something that has to be addressed in the will because it will pass completely outside of it because it is a private contract. Um, so that's really life insurance. So there are Other types of accounts in financial institution that allow customers to name a beneficiary on their bank accounts, their investment accounts, and then those accounts, if you do have a beneficiary appointed, those accounts would also transfer automatically upon death without the need for probate or um, without the need for probate. So generally speaking, most bank accounts will have a 30-day freeze after someone dies, and the beneficiary in the account will have no access to the funds in the account until the owner's death certificate is produced. So again, if I have a bank account and I have set my beneficiary, we don't need an attorney or probate court to transfer that account. Once someone has died, the beneficiary could take the death certificate into the bank and that account would transfer automatically after death. Similar to beneficiaries, is what's called transfer upon death designations. These act a lot like beneficiaries, but some accounts or negotiable instruments require a transfer upon death designation, where some are going to call it a beneficiary designation. Again, they really do the same thing. So for example, someone is telling me that their credit union had them set up a beneficiary, but then their, Fifth Third bank account had them set up a transfer upon death designation. It acts the same way. It's just what we call it is a little different. Um, so one thing I do want to emphasize is that it is better to appoint either a beneficiary or a transfer on death designation on an account over adding someone as a joint owner. So if you add a family member to, for instance, your bank account as a joint owner, they now own that account with the same powers that you do, which means they can withdraw money out of your account and there's really no recourse you can take against that person because they own it with the same rights that you do. Another risk with joint ownership is creditors. So if you add your child onto your bank account as a joint owner, and that child has debt that's not being paid, garnishment, they can garnish your bank account because they are the joint owner to recoup that debt. You might not even know about the debt, and all of a sudden there's money gone from your account, and that's why. So we always caution against adding a joint owner onto bank accounts, and we recommend using beneficiaries or transfer upon death designations. Um, I know at the last presentation that Tracy also talked about financial powers of attorney. So if you're interested in having someone help you with your banking, it's better to set up a financial power of attorney than to add them as a joint owner onto the account. And if you do set up that power of attorney, you can provide that power of attorney to the bank so the bank is aware and it just doesn't transfer those ownership rights over. I also wanted to briefly mention transfer of vehicles or other titled property, such as a boat, a trailer, or a mobile home. Those types of properties can be transferred to a legal spouse or blood relative that would have otherwise inherited without probate court intervention up to a $60,000 value. So if I own a car and I die, my direct heir could go to the Secretary of State and transfer the title without needing to probate it as long as the value of that vehicle was under $60,000. The fees to do this are very minimal. You need a copy of the death certificate and there's a form that you need to fill out. So that can be a good option for, types of property or vehicles, or other property, titled property. So like I said, boats, trailers, vehicles. Um, Oftentimes what you would do is you might say in your will, I'm leaving my vehicle. You would put the name or, the make and the model and the VIN number. Then you would say who you want to leave that to. And then the person who you left it to could take a copy of the will with the title of the vehicle and the form, and then they could go transfer the vehicle to themselves and they would not need to probate that titled property. I'm just pausing for questions just in case. Okay, so the next thing I want to talk about is Ladybird Deeds, which is a really amazing estate planning tool. And Michigan is actually only one of 5 states that allow for this type of deed. So it's really great to take advantage of it if you're in Michigan. Um, you know, one problem that we have in Michigan and especially the Detroit area is what we call heirs property. Property who is owned by a family member and then never transferred properly. So you have property that's, generations have passed and it's still in, someone's name, from 1900. And some those kind of properties are ripe for fraud and people to kind of take advantage or to try to foreclose. And so it is really important to use these tools so that we don't want property to leave the family. It's a really valuable um, asset for families. So, uh, anyway, that's kind of my soapbox. But what a ladybird deed is it creates a future ownership interest in property, and then the property will automatically transfer upon death. So the great thing about a ladybird deed is it doesn't require probate. You must file it with the Register of Deeds when you execute it, but it doesn't become effective until a death certificate is produced. So, for instance, when you buy a new property or transfer property, the property tax cap, um, there's a property tax cap, and when you transfer it, that uncaps, and that doesn't happen until the death of the owner. Even though you might execute the Ladybird deed and the person doesn't die for 10 years, well, that property tax cap doesn't uncap until the death occurs, and the transfer doesn't actually happen until the death occurs. Um, Another thing to know, and I know it's kind of a small detail, but is once the death does occur, you would need to file the property transfer affidavit with the city tax assessor's office within 45 days after death. The other great thing about a ladybird deed is it doesn't trigger Medicaid divestment. So, maybe but if you want to qualify for Medicaid, they do a 5-year look back to see if you've divested any property within 5 years. And so, if I've done a ladybird deed on a property I own, that would not disqualify me from Medicaid. But if I had just quit claim deed a property to somebody, to a family member, that would trigger divestment for Medicaid purposes. So that's another really valuable thing about a ladybird deed. And then again, similar to my caution about joint owners on bank accounts, I will also caution you against transferring real property to a family member and pursuing joint ownership before death. So for example, let's say you deed your property to yourself and your child, at some point before you die. And you're thinking, oh, this is great. I'm going to deed the property to me and my child, and then they won't have to probate the property when I die. Well, the first concern that I have with that is that it will count as a divestment of property for Medicaid purposes. So now you're going to be disqualified for Medicaid for 5 years. Second, now two people own your home. So if you want a home equity loan, you would need to have both you and your child are going to need to qualify for that loan. Anything you do now is going to require both people to qualify and to agree. And then again, as I talked about before, any creditors that your child has now can also, now that home is also an asset to them. So if your child is sued for some sort of a debt, it's possible that a lien could get placed on your home in a collection lawsuit based on a debt that isn't yours, but now based on the joint owner. So, for these reasons, we do really highly recommend a ladybird deed over a quitclaim deed or any other type of property transfer. Um, so I'm going to take a pause. I got one other thing I want to go over, but take a pause, make sure there's no questions on that.
All right, so there is a question in the chat. Does the Ladybird deed disclosure upon filing who you are willing your property to?
Yes, it would state who is getting the future interest in your home. So you would need to designate that in the ladybird deed. And it would be, on file at the Register of Deeds, which is a public record. So that is something to be aware of.
Would you recommend a ladybird deed for a married couple?
Yes, and we would do a joint Ladybird deed. So you would have both the married couples signing the property over to whoever they want to deed it to after they leave, after they die. I'm sorry. I guess I'll say the urgency for me is higher once one spouse has died. Because if I'm married and my spouse dies, the property automatically goes to me. That just happens with married couples. So, and that happens outside of probate. So now at this point, if I'm a widow and my spouse is dead, there's more urgency for me to do that ladybird deed now because if I die, the property would have to be probated if I haven't done that ladybird deed. But we certainly do a lot of ladybird deeds for married couples. So yes, we do recommend them. And a lot of married couples do like a joint estate plan, and we would you would have one ladybird deed for the couple.
Yeah. That's all for now.
All right. So another thing I want to talk about in terms of real property is when you are leaving an interest in real property to somebody, there are two types of ownership you can provide. So you can either deed them the real property as joint ownership with full rights of survivorship or joint ownership as tenants in common. And both of those do have different effects. So I'm going to go over both of them. So the first one I'm going to go over is joint ownership with full rights of survivorship. So think about this as like a tree. You own property, and let's say you have two children, and you ladybird deed your property to them with full rights of survivorship. That means that if either of them dies, the other person who is still living inherits all of that property. So no probate would be required. It's very similar to the example I just gave with the husband and wife. When one party dies, the other party inherits the full property without needing to do anything else other than record the death certificate. That's full rights of survivorship. The most classic example of this is the husband and wife. Okay, so the other type of ownership is called tenants in common. So let's go back to our tree. You have two children, and let's say those children have grandchildren. Under the first scenario, the grandchildren are not involved. But if you had tenants in common, then basically you would deed your property to your children as tenants in common. And then if one of them dies, their interest passes to their descendants, which would be their spouse or their child. So if you are deciding, if you are doing a ladybird deed, that is one decision point you will need to make is whether you want your descendants to inherit. If you're deeding it to more than one person, you would need to decide if you want them to do joint ownership or tenants in common. And that is something like if you were having an attorney assist you, they would kind of talk that through with you and make sure you understood how that plays out in your life, or your children's lives, or your whoever you're deeding that property to. All right. Oh, I have not been. I didn't know. I didn't move the slides along. So sorry about that. So we will talk about trusts. I'm going to tell you right now that I'm not an expert in trust because we don't do them at Lakeshore. But I can tell you a little bit about it. So, um, in my opinion, there is a need for trust sometimes, but most people do not need a trust. A trust operates similar to a corporation. So when you're alive, you are the CEO of the corporation. And then when you die, you appoint someone else to be CEO of the corporation. But the trust owns the property that is put into the trust. So a trust must be in writing, and it must be signed and dated, and it must be properly executed, very similar to the will that we talked about. But the trust must also be funded, which means we must actually put property into the trust, meaning the trust has to be the owner of the property. So if I'm making a trust and I own real property, I would need to transfer ownership of the property to the trust. I would do a deed transferring the property into the trust. And then, like I said, I'm the CEO of the trust. So until I die, I'm managing it. But once I die, it just passes to the next person, the person that I put, as the subsequent CEO. So the thing people really like about trusts is that they avoid probate litigation. Um, because a trust is not a person, so it can't die. So it doesn't need to be probated. Um, I think one pitfall of a trust is people will pay a lot of money to have it created, and they never transfer ownership of anything into the trust. They don't put their bank accounts into the trust. They don't put their real property into the trust. So then they just have this really expensive corporation they've paid to create, and the corporation doesn't actually own anything, and so it doesn't do anything. Um, so, unless you have a lot of assets, you probably don't need a trust. Like I've talked about, there's a lot of estate planning, a lot of things we can do that will help us transfer property upon death that without probate that are not a trust. Um, I know I saw in the chat. I mean, one reason people do trust is for disabled individuals, and there are special needs trusts that exist that are so that if you do have a child who's disabled and receives some kind of public benefits, that their public benefits would not be compromised upon death and assets transferring to them. So that is one reason why you may need a trust. Another reason people sometimes like to do trusts is if they have, a minor child and they want a lot of control over how those assets are transferred to their child, or anytime you want to have a lot of control, you want to be able to say, you get this item if this or this. Those kind of things just aren't going to work in a will. You would need a trust to kind of have that amount of control over, what happens to your property. Um, So that's I can answer questions about trust to the extent that I know them, but as a lawyer, I will say most of the time I think most people don't need a trust necessarily.
So there is a question regarding trust. Are assets in the trust public?
No. Well, okay, sorry, that's wrong. The trust itself isn't public, but if you deeded real property to the trust, that would be public record because again, registered deeds is public record. That would be the only thing that is public is that the trust owns the real property. Otherwise, the trust itself and anything like what the terms of the trust are not publicly available.
Okay, Vanessa has her hand raised. Do you want to come off mute?
Yes. So I've always questioned what were the trusts for, and I do understand that you're kind of limited. So they're actually utilized to just have more control over when you die, if an event you want to ensure that certain things occur, that's your way of doing it. Like for example, if you wanted your child to complete college and you had some funds, you could say, okay, upon completion of college.
Yes.
Okay. All right. Thank you.
Yes, no problem. I mean, because you could write that kind of thing into a will, but there's not enforcement. But if you do a trust, that's how you would get that kind of thing. Um, yeah. So that's exactly, you understood me exactly right. Excellent.
One last question. So if an event, when it comes to the outstanding debt that a person owes after death, they can't, like for example, your creditors can't sue the trust, or can they?
I will tell you, I can answer that in regard to wills. I don't believe they can sue the trust, but I'm not 100% sure. But for a will, creditors can open an estate against you. But I will tell you in my experience that unsecured creditors will not do that. So, like credit cards. Now, is it possible if you have a mortgage company, and the mortgage isn't getting paid, a secured debt may open a probate estate in order to collect, but most unsecured debts will not open an estate. That doesn't mean that if an estate is opened, they wouldn't participate. Does that make sense?
Yes, But you just said one. I just have one last question. So you're saying that if a mortgage is owed, a debt is owed on a property, there is the chance that a mortgage company could come back and say, "Hey, your deceased loved one owes this amount of money, and I want to collect it."
Yes, especially if it stops getting paid. So, I mean, one thing I've seen, I mean, a lot of times, let's say, your spouse dies and you own a mortgage together, or they own a mortgage, but you're married. The mortgage company would just let you take that over because you're married. And then also, like, if you've been deeded, if you've been willed, if you inherit property, the mortgage company will also kind of let you keep paying on that mortgage. If though you stop paying on it, they will foreclose. And if they need someone to sue, they would open an estate to sue the estate. Um,
Okay.
Most of the time, I'd say, like, at least in my experience, that's all I can speak to, is the people who are, the the heirs are aware of the mortgage and then they start paying it, or they just let it go and they know that they will be foreclosed on. Um, but they're usually aware of it, but I could see a situation where maybe you're not aware of a mortgage that was taken out.
Okay. Thanks.
Yep.
Okay, there is another question in the chat. Can a trust be reversed and can property in a trust be taken out?
Yes to both answers. You can revoke a trust. And you can also, like, if you decided you had your property in a trust and you think, I don't want this property in the trust anymore, you could deed, as the trustee of the trust, you could deed the property back to yourself because you're the CEO. So you can do whatever you want as long as you have the legal capacity to do so.
Thank you.
Yes. Okay, and then last but not least is a will. So a will is going to guide distribution of your assets after you die. So that's, you kind of you address all the things that, where they're going to go in the will. So let's say you have, some jewelry that has sentimental value. You could be specific. I want this piece of jewelry to go to my cousin. I want this piece of jewelry to go to my niece. And you could bequeath whatever property you have to individuals. And then, so what we normally do is we'll do any um, specific wishes about like specific items, like this jewelry box, this football, whatever it is. And then at the end, you'll kind of have a catch-all, like anything else I haven't mentioned goes to my children or my whoever, my person that I have designated. But the will go through kind of all of your stuff and say, what you want to happen to it. And then other things to think about is that name, you can name your preference for a guardian or conservator of your minor child. Um, and you will also, as part of your will, nominate a personal representative who will carry out your wishes. So they would kind of be the person who the cruise director of the will after you died. They're going to be making sure that everything gets done according to your wishes. You can edit or amend a will with what we call a codicil, but it would just be, or you can completely replace your will. You would just need to put it very specifically, I did a will on this date and I am revoking that will, and this will replace it. Um, a will could, like I said, I talked about this earlier, but it could require probate litigation. There's no way to guarantee with a will that there wouldn't be probate litigation, especially if somebody decides to contest the will. Um, so something important to know is just you should let your loved ones know where to find your will. Make sure everybody knows where it is in the case, that you do die. And, you know, so I do want to address something called a holographic will. So you can handwrite a will and sign it, and that is valid in Michigan. The other way to do it is kind of the more formal way, like I talked about, where we have it um, signed in front of two witnesses, and that would be kind of a more formal will. Um, but for a formal will, you might want to hire an attorney. Um, like I said, my organization, Lakeshore, does assist people with estate plans in Oakland in Macomb County, if they're seniors. We also help low-income folks in Wayne County. But you can hire an attorney. My advice, if you were hiring an attorney, is to go through one of the local bar associations. So every county has a bar association. And most of the time, I would recommend the lawyers who are active in the bar association, or you can use recommendations of family and friends. I'm skeptical. There are attorneys out there who, would maybe charge you more than is appropriate, or they're gonna, tell you you need a trust when you really don't need one. So, I guess not all attorneys are created equal. So just be cautious and wary and make sure, you hire if you're gonna hire someone that you hire someone that you trust. Any other questions at this point?
Yep, I see another question. Do you have to pay taxes on a trust once the CEO is deceased?
I don't believe on the trust. I think that anytime you're transferring property, you might have to pay taxes on the property, but I don't think the trust itself would trigger. But if the property transfers ownership of a property, then but I'm going to be honest, I'm not an expert on tax and trust. So if you're wondering about how something is going to be taxed, that might be in your interest in a trust, you might want to talk to a private attorney about that because I'm not an expert. But I will say, I mean, I guess, and again, I'm not an expert, but I think that the tax benefits of doing a trust have been really largely phased out in the laws. So my understanding is that the limits, like the cap on taxes is so high that unless you're, a millionaire, it really they don't impact trusts. Like the laws have been changed to the point where it's like wills or trusts, the taxes are going to be the same. And the protections don't really start until we get into very, very large estates. So I hope again, I'm not an expert, but that's my understanding of the state of the law.
Okay, yep, they said thank you for that answer.
So I do have more time for questions. I'm going to just do this little part is we are very thankful to our funders who fund us and allow us to do this kind of work. So we are funded by the Legal Services Corporation, the Michigan State Bar Foundation, the Area Agency on Aging. I'm sorry, I didn't catch this. They are now called Ageways. Um, I'll make sure I correct that. We are funded by United Way, the Oakland County Bar Foundation, and the St. Clair Millage, and generous donations from community members. And I will hang around for questions, but I do want to ask that as part of our funding, we do, our funders do want us to get surveys. So if you have a moment to fill out my survey, I would really appreciate it. But so and I will stay and answer more questions, or, chat or whatever people want to do. And sorry, one more thing. If you're interested in having an estate plan done by Lakeshore Legal Aid, you can note that on your survey. And then I also put the number for our intake hotline here. So either way, if you fill those out, someone will get in contact with you. I always say, listen, we are free. We are not fast. So don't expect a call tomorrow, but you will hear from someone and we will get back to you, but just, it might not be tomorrow, but, someone will get back to you.
So if you've got an issue that you think you qualify for, and it's not a lot of help that you need, but you need a little help, you just call the number or what? How do you go about getting some help?
Yep, you just call the number and that's our intake hotline. So then you could talk to an attorney on the hotline and they would give you advice. And then if you needed, like for instance, if you needed a estate plan, they'd refer you to one of our local offices. And then alternatively, if you wanted to fill out the survey, um On the survey, you could just say, I want someone to contact me, and here's my contact information. But either way, you're gonna, be able to talk to someone. The hotline, is a hotline, so sometimes there's a wait. So that's kind of those are the advantages and disadvantages of both, I would guess. Is you could call that hotline and you could talk to an attorney today, but you might have to wait on hold.
Okay. So is there a resource for um individuals who just need a little help or just kind of like they've come along in terms of what they're doing, but they don't need a lot of help, but they need some direction, you know, this still would be the resource, or there's some other resources one would look at as well.
I mean, if you're in Oakland or Wayne, or if you're in Oakland or Macomb County and you're over the age of 60, I would say this is probably the best resource. Um, and then if you're in Wayne County, there is another agency that does estate planning for seniors over the age of 60 for free. Um, and so that's those, yeah, I would say this is the best resource. And I mean, I think we do pretty good.
Okay, thank you.
Yeah, no problem.
Right. Well, we thank you all for attending. Again, still open for questions. In the meantime, I did drop a link in the chat for you to complete the SRC's evaluation. I know it feels like, oh, all the evaluations, but it ours is a little different in that it helps us understand what you all find valuable in these different trainings that we offer, and if there's anything that we can do to improve, and if you have any suggestions on topics that you are interested in learning more about. So that link is in the chat. I will also share my screen so you can take a look at the QR code for that. So if you can take a moment to do that before you leave. I will also send out a follow-up email that will have your certificate of attendance as well as the link to the evaluation. And again, we do want to emphasize, please stay connected with the SRC. Again, another QR code, but it's all right. They're quick and easy. But this will just take you to the links so that you can access or subscribe to our different social media platforms, as well as the link to our website. So again, we thank you all for joining us. We appreciate your time, and we do hope that you find value in the trainings that we bring to you. I want you to have a wonderful rest of your day, and we'll see you again soon.
Thank you.